Blindsided by a restraining order without the chance to defend yourself? Well, that's what's called an ex parte order, and here's what that means. So you've been served with a restraining order, or more commonly known in Indiana as protective order, and at the bottom, you've seen that it's been granted. That's called an ex parte order for protection, and what that means is the judge granted the petitioner's petition for a protective order without a hearing. And there's a variety of reasons of why a judge may do that. Someone files a restraining order in Indiana, the judge has three options. The judge can outright dismiss it, the judge can set it for a hearing, or the judge can grant it ex parte, meaning it goes into effect immediately. Now, if you're served with an ex parte order for protection, that means that you are at that point not to have any contact whatsoever with the person that filed it, or you can be charged criminally with invasion of privacy, which is a Class A misdemeanor. Now, the reasons why a judge may grant a petition for protection ex parte typically depends on whether or not there's immediate threat of that person's safety. So if there's allegations of domestic violence, if there's allegations of severe harassment or stalking, to the point where the judge doesn't think that there's enough time to get in front of her or him for a hearing, and that the petition needs to be granted now in order to protect the petitioner. Now, if you've been served a protective order that's already been granted ex parte, there is a way to get in front of a judge, but there's a quick timeline that you have to adhere to. If you're served with a petition for protection and that restraining order is granted, then you have 30 days to request a hearing to get in front of the judge to show your side of the story of why that protective order should be denied. Now, the big thing you're going to want to do is hire an attorney immediately as soon as you see that a petition for a protective order has been granted ex parte. And that's because an attorney is going to be able to request the court to have a hearing on that restraining order and also be able to cross-examine the petitioner, cross-examine our petition's witnesses, present our own witnesses, present our own evidence, and argue to the judge as why this order for protection should be dismissed. If you're facing a restraining order, if you've been served with a restraining order that has been set for a hearing, if you've been served with a restraining order that has already been granted, and you're still within that 30-day timeline, please give us a call at the Marc Lopez Law Firm, 317-632-3642, and always remember, plead the fifth.